بسم الله الحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه ومن والاه ثم أما بعد. To proceed. So today, inshallah, we will go over four maxims, and they are, the first two are a little bit longer than the second two, but we hope that we will be able to cover them all today, inshallah. The first one is تشرع القرعة إذا جهل المستحق وتعذرت التسمية. Okay, تشرع القرعة إذا جهل المستحق وتعذرت التسمية. So القرعة is what? Drawing lots, lottery, basically. Lottery, drawing lots. تشرع is legislated. إذا, if جهل became unknown or is unknown. المستحق, the entitled party. Entitled party is unknown. جهل. جهل would like be unknown. No, known. Unknown, became unknown. جهل. وتعذرت became impossible. Well, let us for brevity say is impossible. التسمية, designation. Is it self-explanatory? It is self-explanatory. It's a very simple, straightforward qaida. We don't need to spend too much time with the explanation. So whenever there is an entitled, like a party entitled to something, and we are unable to identify that party, designation is impossible. The party is unknown, designation is impossible. Then we do what? Lottery. We draw lots. Okay. And basically, drawing lots is a method used to resolve disputes or assign rights in a fair and impartial manner when there is ambiguity or conflict or competition. So if we cannot determine the rights decisively through evidence, then we defer to a process, a mechanism by which we can do this impartially and in an unbiased way. Impartially and in an unbiased way. This is a random mechanism that will remove what? Human bias. That's what we want. Well, that's what we're after, because we do not assume that humans don't have self-interest. We assume that humans usually have bias, preference, self-interest, and in order for us to do this fairly, when there is no evidence to designate rights, assign rights to different entitled parties, then the only way we can go about it is by qur'a, or by drawing lots. And we will see where that works and where it doesn't, at least in the madhab. That's the first, that's the explanation of the qaida. One thing that we want to say at the outset is that the Sharia does not prescribe any particular mechanism for, that process for lottery. It doesn't prescribe any particular mechanism. And Imam Ahmad was asked, what should people do? Should they write slips? You write a slip, that has your name, and then put the slips, and someone picks one of them, riqa'. He said, إن شاءوا رقاعا وإن شاءوا خواتيمهم. So if they desire, they do it by slips, and if they desire, by their rings. By their rings means what? Means that each one basically puts his ring in a pot or in like someone's pocket, for instance, and someone reaches and picks one of those rings, randomly, and whosoever's ring comes out, they win. So do we have proofs? Yeah, the Quran prescribes that this is a process that has basically been implemented, employed in the past by righteous people. And behold, when they were casting their pens, which one of them will be, to determine or to decide which one of them will be in charge of Maryam, Mary. And the Quran also says about Sayyidina Yunus, فَسَاهَمَ فَكَانَ مِنَ الْمُدْحَضِينَ. So he participated in the drawing of lots, and he was among the losers. And that is when they were, trying to figure out who they will basically throw overboard, I guess, to lighten the burden of the ship. So they drew lot to figure this out. Is that fair? Yes, it is fair, because otherwise, it's pretty fair, actually, because otherwise, if someone has to be thrown overboard, I mean, regardless of, the particular thing, but the process itself is a fair process. Then it was also reported from Abu Hurairah radiallahu anhu that the Prophet sallallahu alaihi wasallam said, had people known the reward in the call to prayer and in the first row, in the Jama'ah, the first row, and they would have not been able to attain that honor except by drawing lots, they would have drawn lots. لو يعلم الناس ما في النداء والصف الأول ثم لم يجدوا إلا أن يستهموا عليه لاستهموا عليه. And then we have also Aisha radiallahu anha tells us that the Prophet sallallahu alaihi wasallam, whenever he used to go out on travel and to be accompanied by one of his wives, he would basically draw lots among them, between them. And that is actually in the madhab wajib. So if someone has more than one wife and they needed to do, they had to do something with one of them, or to start with one of them, they draw lots. And it's wajib in the madhab. Okay. And so these are adilla, or proofs from the Quran and Sunnah. Do we have anything else? We have consensus. This qaida is a matter of consensus. Do we have anything else? We have the proof of reason, which we employ. Ahl Sunnah employ the proofs of reason. And as we talked before, there is the definitive and the speculative, and scriptures and reason and so on. But reason also accords with this principle, because it helps us avoid wrongdoing and human bias, which humans are notorious for. So let's do some applications. But let us first listen to Imam Ibn Rajab. By the way, this qaida is the 25th of al-Qawaaid al-Sa'diyya. And for Imam Ibn Rajab, it's the qaida number 160. Qaida number 160. How many qaidas does Imam Ibn Rajab have? 160. So this is the last qaida in Ibn Rajab's book, 160. So he says, lots are used to distinguish the entitled, the recipient, when entitlement is originally established for someone unknown and undetermined. Those entitled are equal. They're also used to distinguish the actual entitled party when he is determinable in reality, but unknown due to confusion or the inability to ascertain him. So sometimes the person is completely unknown, and sometimes the person is unknown, but we are unable to know them. So where does it apply? He says it applies in wealth and in marital relations. There is wealth by agreement in the madhab. Marital relations, like property, disputes over property and things, in agreement in the madhab. Marital relations, there is some disagreement in the madhab, and we will mention some examples about this, but there is some agreement in the madhab, but the apparent view in the madhab is that qara'a, lottery, also applies to marital relations, which is a huge thing because it will determine who's halal and who's haram, you know, who's been divorced and who's not. It's a huge thing. We will mention some examples. He says that lots are not used to establish lineage, and that's the apparent view of the madhab, but this is a controversial issue. If we fail to establish lineage, completely fail to establish lineage, and there are several examples, but let's take the easier ones that are not basically mind twisting, you know, hospital mix-ups, stuff like that, wars, things of that nature. If you're unable to establish lineage through evidence, do you use lottery? In the madhab, the apparent view of the madhab, no. But there is another view in the madhab that it is permissible when you are completely unable through evidence. He says they are used in rights of priority, authority, and similar matters. Rights of priority, authority, and similar matters. So over wealth, to determine who's entitled to this property. Over priority and authority, to determine who is entitled to adhan, or even imamat al-salah, to be the imam in salah when you have two people that are completely equal, but they compete and they vie for it. And you're unable to determine, even for imam al-kubra, even for the highest office in the land, when you have two people that are completely, so when you have like a tie, for instance, in elections, and the two people are completely equal in everything, then how do you determine who will be the Khalifa, the Sultan, the Imam, the President, whatever? Is determined through drawn lots, because you're removing here human bias from the process. It may sound to you ridiculous a little bit, but it is not, because they are saying this is on condition that you have no other way to basically prefer one over the other. And if you have no other way to prefer one over the other, then that process takes away human bias. So then he says, there is also a weak view in expiation that lots may distinguish a forgotten oath. So, which means what? Which means that the position of the madhab is that lots will not determine a forgotten oath for you. Like, which oath did you make and forget? But there is a position in the madhab that lots may determine, distinguish a forgotten oath. Okay, so we said vie for the call to prayer, and they're equal. We said vie for leading the prayer, and they are equal. They are two relatives of a deceased person, and they vie for leading the janazah prayer on their relative. Then qura. You have two deceased persons that come to a public cemetery, like like a charitable cemetery. Two deceased persons that come, and they come to one spot at the same time. Which one? Qura. You have two persons claim a deposited item, and the keeper of the deposited item forgets who left this item with him. Qura. You have two persons who want to basically set up like a shop, or not a shop, but whatever, those like vending carts, or like in one spot, public spot. And we don't have any way to prefer one over the other in terms of entitlement. Qura, lottery, you have, but if they are competing over like a property, for instance, for like a like to make a living, they compete over an unassigned, unowned, unassigned mine. For instance, they compete over it. Then we have two different positions in the madhab. One, draw lots. The other one, which was chosen by al-Qadi, that is al-Qadi Abu Ya'la. When al-Qadi is mentioned in Hanbali madhab, it's al-Qadi Abu Ya'la. So the other one by al-Qadi is al-Muhaya'a, which is basically to let the imam assign different days or different hours for each one of them. So if they have position simultaneously, that is, they put their hand is on it simultaneously, then we divide it between them if it is divisible. If they are vying for it and it's unassigned, then we basically assign it to one of them a certain number of days, and the other one a similar number of days. 1 week for them, 1 week for this X, and 1 week for Y, and so on. The idea here is to try to be as impartial as possible and to take away from the process any human bias. So a man who leaves wives and he had divorced one of them, and this divorce severs inheritance. So these are hypotheticals, but in all honesty, and to be honest with you, I believe that one of the areas where there are like some issues that need like some figuring out, and that we can't really like. Certainly, as a Muslim, you have to believe in the infallibility of the Quran and Sunnah, but the infallibility of the tradition, you don't have to believe in that unless there is a definitive, verifiable, unquestionable consensus. But if there is not a definitive, verifiable, unquestionable consensus, then you don't have to believe in. In fact, you shouldn't, because this is human effort at the end of the day. So the area of divorce in general, if you read the chapters, or you try to study the chapters of divorce, you will have some discomfort with parts of the tradition. Anyway, but what they're trying to do here is impartiality, removing human bias. So he divorced one of several wives, and then we don't know which one was divorced, but her divorce basically severs rights of inheritance, and he died, then we have to determine this, then a lottery would be the way to go. Co-equal guardians in marriage, also people entitled to custody. So you have like a girl, for instance, and her father is dead, and she has two uncles, and they vie for guardianship in her marriage lottery. You have a girl who or a boy, and they don't have someone who, like, when it comes to custody, their custody basically is now between two equally entitled relatives, like two maternal aunts, like two khalas, for instance. Which one takes the boy or the girl? If they vie for it, then we use qura, lottery. Lineage cannot be established through qafa. Do we use a lottery? We said that in the madhab, no. So it is not used in lineage. Maybe they considered it to be too serious for Qur'an, but at the end of the day, there is a position in the madhab that says when there is no evidence whatsoever that can be used to determine, then lottery would be basically the unbiased, impartial process that would save the day. A boy reaches 7 years and refuses to choose between his two parents. They said lottery. Another view said we'll stay with mom, with the mother. So because she was entitled before 7, فالأصل بقاء مكان على مكان. So the default is basically presumption of continuity. So we have two views. Lottery or stays with mom. As supreme imama, we did say this because at the end of the day, if you have like a tie, it's determined by Qur'an. So why did Umar radiallahu anhu add his son Abdullah ibn Umar to the 6 people of Shura to be a tiebreaker only? Because he had stated that he will not be the Khalifa. So he stated that I'm adding my son Abdullah ibn Umar to be a tiebreaker, not the Khalifa. Because when you have 6 people and you're like, you can have a tie. So if you can have a mechanism to avoid the tie, then it would be better to basically establish a mechanism to break a tie. So if we have, if we have like a Majlis Ahl al-Hal wal-Aqd, you want to have an odd number. If you don't have an odd number, then you will have to say the president of the council will be the tiebreaker or something, some process to establish, to basically resolve the problem of tie. One of the contemporary applications is Hajj lottery and Umrah lottery. Is that a good thing? It is a good thing, Hajj lottery. And is it a good thing that America has a lottery for immigration? I think it is a good thing. We should certainly for some people, like whenever you say anything good about anybody, it gives them like a complete meltdown. Because, anyway. So in America, there is a lottery for immigration. Is that a good thing? I guess it is a good thing. If you say it is a good thing for us, then it must be a good thing for others as well. Otherwise, you'll just have like a blatant double standard. Anyway, so that is the first qaida. The first qaida is an attempt to basically address the problem of human bias by having a random process to determine eligibility, to determine priority, to determine authority, to determine entitlements, if the above cannot be otherwise determined through evidence. Okay, the second qaida that we will go over is إذا اجتمع السبب والمباشرة, and this is a very important qaida, by the way. إذا اجتمع السبب or التسبب. Tasabbub would be causation, sabab would be cause, causation. Okay, wal mubashara. Mubashara would be what? Direct action. قدمت المباشرة. Direct action will take precedence or will be more accurately given precedence. إذا اجتمع, when they coincide, right? How did I translate this? Coincide, yeah. When they coincide, when sabab al-mubashara coincide, when causation and direct action coincide, direct action will be given precedence over causation, and then applications will make this clearer. So a single harmful act may involve more than one person, some acting directly and others by causation. So to whom should liability be assigned? To whom should liability be assigned? You dig a pit in the ground and someone pushes a person into it. Who's liable? If that person gets like a broken leg or dies or something. That's like a quick example, but we will come to many applications. So this qaida is number 127 in al-Qawaaid al-Rajabiyya by Imam ibn Rajab. And in that, he provides like a lot of nuance. And we will see how it's nuanced. But the generality of this statement is still applicable, because as we will see, Imam Rajab will come back, and in the 89th qaida, he will say the following: liability arises from three causes: contract, position, that is al-yad, al-aqd, al-yad, and destruction, al-itlaf. As for destruction, if it is not possible to assign liability to the direct actor, it is assigned to the one who caused it. So another formulation of this qaida is that in cases of destruction, if it is not possible to assign the liability to direct action, it is assigned to the cause. So the liability will go first towards direct action, not the cause. But sometimes direct action is clear of liability, and that is where the nuance comes in, and that is where we have to basically figure out the different scenarios. But the general wording of the qaida stands. The primary locus of liability is not causation, it is direct action. But sometimes it shifts, and let's see when it shifts. If the destruction of another's property or life results from both direct action and causation, liability attaches to the direct action rather than the cause, unless the direct action is built upon and generated by the cause, whether that causal pressure is compelling or non-compelling. In such a case, the direct action contains no element. If the direct action contains no element of aggression, the cause alone bears liability. Okay. So we will have three different scenarios. One scenario, or first, it is two-pronged. Direct action. So direct action. Direct action is built on and generated by the cause. Direct action is not built on or generated by the cause. And we will take examples. All of this will be clear, inshallah. This one, built on and generated by the cause. The direct action basically involves aggression. direct action does not involve aggression. Okay, if the direct action and the cause they just coincide. You know, they're not built on one another. They just coincide. So when someone digs like a well or something, and someone pushes you into it, who's responsible when they are not built on each other or generated by each other? They're not, you know, the direct action is not built on or generated by. Who's responsible? Direct. Okay. If the direct action does not involve any aggression, let us say, you know, the example that he will give, you basically, someone gives you a poisoned food and you eat it, not knowing that it has poison. The direct action that caused the death is your eating. But the person who gave you the poisoned food basically caused it through causation, not direct action. Who's responsible here? The cause, of course, because the direct action does not involve any wrongdoing. Direct action does not involve any wrongdoing. If the direct action involves wrongdoing, the cause, you know, is basically wrong, and the direct action is also wrong. What would be a good example here? If I basically order, like some one of you, X to kill Y, and X kills Y, I compel even X to kill Y, and X kills Y. Who's responsible? Both of us. So it is shared. Liability is shared here. Liability will go to the direct action if it is not built on or generated by the cause. Liability will go to the cause if the direct action is free of guilt. It is built on and generated by the cause and free of guilt. Liability will go to both if the direct action is built on and generated by the cause, but is not free of guilt. Guilty also. Okay, so let us take some examples. The first category, this is the first category. Not built on, they just coincide. First category. Someone that digs a pit wrongfully, another one we call this. Someone opens a cage that has a bird, and someone frightens the bird away. Who's responsible? No, the one who frightens the bird away, because that's direct action. You know, the one who opened the cage, it's my mistake, not yours. The one who opened the cage, he opened the cage, but the bird sat there for a little while in the cage. And then someone frightened the bird away. Then the person who frightened the bird away. Someone throws a person. Inviolable is my translation of Ma'soom. Someone throws an inviolable person from a height, and another received him with a sword. The one who received them with a sword. They consider this to be, these things, Again, the idea here is this is the tradition. These are fuqaha, great people, enlightened people, but they are not infallible among themselves all the time, as we have seen. Anyone who attended one or two of these sessions should have realized among themselves all the time, and that's completely fine. So treating the output of fiqh as holy and infallible is just something that is uneducated. No? You throw someone from a height and then someone receives him with a sword. Who's responsible? The person who receives him with a sword. What? Yeah. But there is another example that you may like. So someone who strikes, that does not mean that the person who threw him from the height will not be punished, will not be disciplined. And that disciplining could be like a punishment, 5 years in prison, something like this. But who killed him? The person who received him with a sword, because that is what resulted directly, sort of the final effective cause in the killing was the sword. So they want to figure out who killed him. Are they going to punish everybody? Yeah, but we want to figure out who killed him. So someone strikes a woman's abdomen and she miscarries. And then another person basically kills the fetus. The fetus came out with حياة غير مستقرة, an unstable life. We have 3 different types of حياة in fiqh. We have الحياة المستمرة, الحياة المستقرة, we have الحياة المستمرة المستقرة المذبوح, and المذبوح is غير مستقرة. So basically مذبوح is slaughtered. So if you kill someone who has a حياة مستمرة, you are the killer. مستمرة means what? Like continuing, like stable life, continuing stable life. If you have someone who is in a state of حياة غير مستقرة, Umar radiallahu anhu, after he was stabbed, is basically when they told him that you will not live, or like a better example, someone who, got like a fatal injury, and it is certain that this person will not live, but there is still movement, there is still something. This is حياة غير مستقرة. That fetus is called the حياة غير مستقرة. That fetus who's been miscarried, and now it's out, and it is shivering, moving, whatever, and someone kills that fetus, then who killed both will be punished. But who killed him? The first or the second? The first in this case, not the second. It's different from the height and the sword. Why? Because the second person found him in حياة غير مستقرة, a state of unstable life, in a state of unstable life. The other one who had been thrown from the height was still living at the time he was stabbed by the sword, was still alive by the time he was stabbed by the sword. Well, if you detect that he had died from the shock or from the, but that's a different story. But they presuming that he was still alive when he was stabbed by the sword. Therefore, the final effective cause of death was the stabbing. For the miscarriage, the final effective cause of death was the blow to her abdomen. because when a fetus came out, the fetus did not have a stable life. The fetus had unstable life. Okay. So that's how much the effort they put into this to determine what? The final effective cause. So the second category, no aggression in the direct action. We talked about, the poisoned food. A judge carries out or qisas punishment based on false testimony. A judge carries out a hadd or qisas punishment based on false testimony. Who's the killer? The witnesses who basically furnished that false testimony. What is their punishment? According to the majority, death, including the Hanbalis. False testimony is punishable by death if it results in death. And that is the position of the Shafi'is and Hanbalis for sure, and one of the two positions within the Maliki madhab. Okay. Then he also includes in this category the one coerced to destroying another's property. The one who's coerced into destroying another property. You remember the example I gave earlier? I command X to kill Y. X kills Y. Who's liable? I and X, or X and I. Why? Because X is guilty. Because you cannot basically, even under compulsion, kill someone else. Or rape. Killing, raping. You cannot do this. These things, these are red lines, even under compulsion. Even under compulsion. Okay? But if I tell you to destroy some person's property, or otherwise I will kill you, in this, under compulsion here, you go and destroy that person's property. Are you guilty? There is a disagreement in the madhab, but the position, the apparent position of the madhab, or the dominant position in the madhab, authorized position in the madhab, you're not guilty. You're not guilty. You can go ahead and destroy the property to avoid death. Then the property owner now wants to claim their right. Can they come after you for compensation? Yes, they can. Because at the end of the day, you are the property. They can come after you for compensation. And then, in turn, you will go after the person who compelled you in court for compensation. You will be liable, not finally liable, but liable to the owner of the property. Eventually, you will get reimbursed, I guess, by the court from the compeller. Okay, now, does that apply to killing? No, it does not apply to killing. If someone orders you to kill and you kill, you will share liability. You will share liability because you're not allowed, you're guilty here versus destroying property. The third category, so this was the second category. The direct action does not involve guilt. The judge acted in good faith. The person who destroyed someone's property was allowed to do this under compulsion. Under compulsion. The person who ate the food did not know that there was poison, and so on. Here, the cause will be liable. The cause will be liable, not direct action. Let us take the third category. Third category is there is aggression. And we already gave you the example. If I tell X to kill Y, X kills Y, X and I are liable. Shared liability. Shared liability. That's it for this guide. Just try to remember that three-pronged division. Three-pronged division. First division is the direct action is built on and generated by the cause, not built on or generated by the cause. Mere coincidence, not built on or, okay. Mere coincidence, direct action will be responsible. Built on, the direct action is built on and generated by the cause, then we have another question to ask. Does the direct action involve guilt, wrongdoing or not? And if it doesn't involve wrongdoing, the direct action is free of liability. If it involves wrongdoing, they share liability. Next, ما تشتهيه النفوس من المحرمات ففيه الحد. Can disambiguation? For Qur'an, for what? Yeah, of course. That which النفوس nafses desire of the prohibitions ففيه الحد, then is subject to had the punishment, or how did I translate this? Carries a had, or subject to had the punishment. Had. Okay, this is an important part because it will help you understand the philosophy of legislation and the philosophy of قانون الجنايات, قانون العقوبات, penal code of laws in Islam. الإمام تقي الدين ابن تيمية رحمه الله said وقاعدة الشريعة أن ما تشتهيه النفوس من المحرمات كالخمر والزنا ففيه الحد وما لا تشتهيه كالميتة ففيه التعزير. The principle of Sharia is that those prohibited acts which the nafs desires, such as alcohol and fornication, carry a prescribed punishment or had, whereas those that are not desired, like carrion, eating carrion, carry a discretionary punishment. And Sheikh Sa'di rahimahullah said, والوازع الطبيعي عن العصيان كالوازع الشرعي بلا نكران, which will translate to natural deterrence from disobedience is like the Sharia deterrence with no rejection. So explanation of this is that, sometimes you have a natural motivation and natural deterrence, and Shari'i motivation, Shari'i deterrence. The Sharia tries to balance things out. So when you have weakness in the natural deterrence, the Sharia raises the Shari'i deterrence. Okay? The same applies to motivation. When you have low motivation, the Sharia adds motivation. Low natural motivation, the Sharia adds more motivation. Let's take some examples. And certainly the evidence for this is istiqra, inductive reading, or inductive in reasoning by comprehensive review of the Sharia laws. So what are the hudud? The hudud are, sariqa, zina, khamr. What is the, basically there is so here sariqa is after money, zina is known after what? Khamr is like an addiction. So these things, basically, someone may say, what about qazf? Qazf is not, it is basically the rights of people to begin with, but it is also not about attraction or pulling. It's about pushing, because anger is pushing you. Usually when people commit qadhf, they are being pushed by anger. So if the pull is intense, or the push is intense, the Sharia wants to stop you from breaching the fence, violating other people, or violating the laws of Allah when the pull or the push is intense. Yes, qadhf, accusation of false testimony is going to be punishable, but at the end of the day, the pull and the push here, these are the hudud of the Sharia, because it is clear that the pull and the push, the natural basically force that is acting here is too high, so you need to higher the fence. You need to make the fence higher than the natural force that is pushing you or pulling you, that is pushing you or pulling you. So why is it that the Sharia does not basically preach to us, a lot? It does preach to us about the importance of, good sleep and eating and drinking and things of that nature. But the Sharia is counting on the fact that human beings will eat and drink. It's just like there is a natural inclination to sleep, to eat, to some extent to get married. Although the Sharia does encourage marriage because of the importance of marriage, but it's not like a million hadith about marriage, because people at the end of the day would want to get married. Earning also to make a living. The Sharia does address this. The Sharia does encourage this. But how many hadith, push in that direction? Not many. Why? Because the Sharia is counting on the natural inclination. Some people have low motivation. So that is why it is the responsibility of the mashayikh, basically, to reset the public sort of awareness and consciousness and conception of the Sharia. So if you have like a community where people are just disinterested, unmotivated to earn a living, to do then it will be the responsibility now of the mashayikh to do the work of highlighting those, so whenever we talk, نعم المال الصالح للرجل الصالح, it's just like one hadith that is somewhere there, in hundreds of thousands of hadith. So why is it that in particular times you'll find the scholars basically putting the limelight on this hadith to correct a misconception, a public misconception, or a public misinclination, and so on. But anyway, so the Sharia leaves those matters to natural inclination or natural deterrence. The same applies to virtues, So the Sharia does recognize that honoring your parents and honoring your children, like commitment toward parent and child, الإمام القيم رحمه الله says أكثر الفساد الموجود في الأولاد تجده من جهة الآباء. Most of the corruption that takes place, certainly Nuh was not able to save his son. So keep that in mind. But at the same time, the responsibility of parenting is huge. And certainly there are hadith كلكم راع كلكم مسؤول عن رعيته قوا أنفسكم وأهليكم نارا وقودها الناس والحجارة. There are ayat and hadith that talk about the importance of that responsibility. But and Imam al-Qayyim says that most of the corruption that you find in children comes from the parents, comes from by being bad role models or by neglecting to take care of their children, to discipline, and so on and so forth. So why is it that the Sharia does not talk a lot about the importance of, taking care of your kids but talks a lot about the importance of taking care of your parents because of the natural inclination. You know, I don't need to remind the parents to take care of their children because they do this naturally. But I need to remind the kids to take care of their parents because they don't do this naturally. Okay. Credibility of the witnesses. Credibility and integrity of the witnesses. Do we require credibility and integrity of the witnesses? But if you're witnessing against yourself, which is admission or confession, do we require integrity and credibility? No. What are we counting on? The natural inclination that you would be protective of yourself. Do we require the guardian to be credible? The guardian of a woman, do we require the guardian to be credible? By the way, in our madhab, we don't. In our madhab, we do, I'm sorry. But the majority and variant position in our madhab does not. And I think Imam Taqiyuddin supports that position, that it is not required, because the fusaq, you know, like if someone is fasiq and he has a daughter who's at the end of the day, he needs to be her guardian and just get her married. But why is it that the majority and that variant position in our madhab, which is not the authorized one, does not require? Because of the natural inclination, particularly when it comes to the father. And there is like a difference between the father as a guardian and everybody else as a guardian. There is a difference between the two. But there is a particular natural inclination that fathers are protective of their daughters. So then, how does that particular qaida benefit us in understanding the Sharia? That the uqubat, the punishments, the hudud, are not basically God avenging himself of humanity. That is God protecting humanity from their sort of evil dispositions. God is helping humanity survive, overcome their evil dispositions by, you know, when God sees that there is like natural force, like a high natural force, then the dam, you know, has to be higher to stop, you know, that force. And that's something that we have to realize. And Imam Taqiyuddin even said that even when you apply the punishment, you're doing it with empathy. You're doing it for the interest of the one being punished, for the interest of the one being punished. And that is people who, like the Pharisees and people with Pharisaic tendencies, that is what they basically miss. People who are legalistic, you know, like spiritually impoverished and deprived, that is the part that they miss. And they use these punishments as a way of revenge, not purification. The final one, which we need to finish, I am sorry, I know that it's been an hour, but we need to finish the final one. It will take about 10 minutes. Because next time we will start with a completely new section, that is al-Qawaaid, that are dominantly and more or mostly related to the chapters of ibadat or acts of worship. The final one in that section, which is the Qawaaid that pertain to judgment and ijtihad and fatwa and so on, is من سقطت عنه العقوبة لموجب ضُعِف عليه الضمان. So whoever saqatat was waived, I guess. Al-uquba would be punishment. لموجب for a cause or for a valid cause. ضُعِفَ doubled عليه against him or upon him. Al-Daman liability. Okay, so whoever has the legal punishment waived from him due to a valid cause, the financial liability upon him is doubled. This is the 35th of al-Sa'di's Qawaaid and the 140th of Ibn Rajab's Qawaaid. So and Imam Ibn Rajab rahimahullah said من سقطت عنه العقوبة بإتلاف نفس أو طرف مع قيام المقتضي له لمانع فإنه يتضاعف عليه الغرم. Whoever has the legal punishment waived from him for destroying a life or a limb, despite the presence of what necessitates the punishment, but due to a preventing factor, the financial liability upon him is doubled. So where does Imam Ahmad commits to this more than the other Imams? Why? Because for Imam Ahmad, this hadith, he said, I can't find anything to resist to this hadith, to stop this hadith. من أصاب بفيه من ذي حاجة غير متخذ خبنة من أصاب بفيه من ذي حاجة غير متخذ خبنة فلا شيء عليه ومن خرج بشيء منه فعليه غرامة مثليه والعقوبة ومن سرق منه شيئا بعد أن يؤويه الجرين فبلغ ثمن المجان فعليه القطع. Whoever eats from it with his mouth out of need without concealing anything in his garment incurs no liability, but whoever carries anything away from it must pay twice its value and receives the punishment. And whoever steals anything from it after it has been gathered in the threshing place and reaches the value of a shield must have his hand cut. Okay, so you walk into an orchard. Keep in mind that this does not apply walking into a private home, because if you steal from a private home, then you will have your hand cut. But you walk into an orchard, even if it is fenced, and you eat off the trees, what should you do? You eat whatever it is on the ground, and you do not pick from the trees. That is what you should do. But let us say you also picked from the trees and ate because you are hungry and did not take anything out with you, did not take anything out of the orchard or the bustan with you. Are you subject to any punishment? No, you're not. No, you are not. You're not. فَلَا شَيْءَ عَلَيْهِ, the Prophet said. As if the community should have figured out, like hungry people should not go hungry. So this hungry person who picks some fruits off the trees and eats but doesn't hide غير متخذ خبنة. خبنة is طرف الثوب. خبنة is basically the end of the garment. So like you're not collecting anything in your garment when you're walking out, okay? Nothing. What if you collect stuff in your garment and you walk out? So you will be liable for twice the value of the fruits and some punishment. Punishment, not cutting, punishment, discretionary punishment. Because the Prophet said, ضمان مثليه والعقوبة, punishment, some discretionary punishment. What if the crops, the produce, has been picked and stored in the baydar or the jareen, the threshing place, or whatever it is, a shed, like storage, barn, etc. And then you walk in and you steal, that's when you get caught. Okay. But what is the point in this hadith? The point in this hadith is that because one of the conditions of qata or cutting off hands is what? To break into like hairs. The bustan is not considered a hairs, to break into basically a secure, say, safe place for storage. The bustan is not considered a hairs, but the threshing place or the barn or this or that is considered a hairs. So since you don't meet the criteria for cutting, we will double the liability against you, because there was a reason. The reason here is what? You did not meet the criteria for cutting. So we will double the liability against you, basically to compensate for that. Let's take some examples. If a Muslim intentionally kills a dhimmi, pay the blood, a Muslim intentionally kills the dhimmi. Well, this is a big deal, but nowadays, in the nation state, can our people afford to act upon the position of the majority, Malikis, Shafi'is, and Hanbalis, and not kill a Muslim for intentionally killing a dhimmi? I don't think so. You guys can have all of your dreams and all of that stuff, and all of your basically whatever. But I don't think it's doable. I don't think it is actually right. So I think that the only way to do this is to go by Imam Abu Hanifa's position that a Muslim can be killed for killing a dhimmi. There's no other way to do it in the nation state. You can't basically go to Egypt and demand them to go Maliki or Shafi'i or Hanbali here, and when like an Egyptian Muslim kills like a Coptic Egyptian, then they will just say, well, he's a dhimmi. But in our tradition, as Hanbalis, and the same applies to Shafi'is and Malikis, so the decisive majority, the Muslim will not be killed. So in this case, what happens? No, of course, the Muslim will be punished, but will not be killed. But so what happens? We basically make him pay the diya of Muslim, not the diya of dhimmi, the blood money of a Muslim, not the blood money of a dhimmi. Is that doable nowadays? No, it's not doable. But also, to be fair to our history at the same time, allegiance to, during these times, the idea of a nation state was not existent. And these were imperial times. And for Islam, it was an empire of faith. Basically, there are two layers of citizens. Yes, in the empire of faith, there are two layers of citizens. In the Roman Empire, there are two layers of citizens. If you're from Rome, you're not like someone who's from Greece or from Alexandria. There are differences. It's not one layer. There are two or more layers of citizens. In the Islamic Empire, there were two layers of citizens. Did not allow for oppression. No, certainly did oppression happen? Yes, of course, oppression happened. Human beings are human beings, and certainly oppression happened. But was that meant to result in oppression? Of course not. The Prophet ﷺ made strict warnings against injustice to dhimmis, and he even said that whoever hurts a dhimmi or mu'ahid I will be his opponent on the day of judgment. I will be his opponent on the day of judgment. And it used to be called the dhimmi from dhimmatillah wa rasulih. It is the dhimma of, this is basically the word or the covenant extended from Allah and His Messenger to them. So there was strict warnings against violating and breaching that covenant that is extended from Allah and Messenger to them. However, despite that, this may not be possible in a country like Pakistan or Egypt today. And in this case, they should be able to pick the position of Imam Abu Hanifa and just act on it. And that's it. So in this case, like a dhimmi kills a Muslim kills a dhimmi. If it is intentional killing, the punishment is the same. Now, you may say, but this is unfair. Because if a Muslim kills another Muslim, the punishment is not one punishment. Yeah, the punishment by death is one of 3 options. The other 2 would be what? Blood money and pardoning. And a Muslim may be inclined to forgive. So it is not fair to basically impose the punishment to basically impose death. We will make it the same. We will make it the same. So it will be offered also, blood money will be offered also to the dhimmi, to the family of the dhimmi. And if they are more inclined to killing, then that's what it is at the end of the day. Anyway, but this is where the change of fatwa here is not basically more than picking one of 4 different madhahib, the position of one of the 4 madhahib, because it is more suitable for our times. If someone conceals, if someone picks a luqata, and conceals a stray animal, for instance, he will basically be subject to twice the value of the animal, because you should announce it. When you find like a stray animal, you should announce it. If you don't announce it, you're subject to twice the value. You're liable. And Imam Ahmad said that this will avert the hadd from him, because he will consider this to be like stealing. If a minor intentionally kills, double the diya is taken from his property. If a one-eyed person destroys the sound eye of another person, sound eye, so like one-eyed person pokes you in the right eye and destroys your right eye. Can you poke their one eye? No, you can't. So why? Because that makes them blind. Him poking your right eye did not make you blind. So it will have to be the diya. The diya here will be what? Doubled. What is the diya for one eye? Half of the diya of life. Because any organ that has like 2, you have 2 of them, then the diya for that organ is half of the full diya. If you have 1 of those organs, then the diya is the full diya of the person. So one eye is 50 camels, and then but the person who poked you in the one eye, I have no ability to seek retaliation from them, because the punishment was waived. Punishment was waived for a mujib, a cause. The valid cause here is that he's one-eyed. Then the liability will be doubled, and instead of paying me for the one eye, he will pay for the 2 eyes, for 2 eyes. This maxim does not apply to cases where the diya is increased for killing a prohibited relative, a mahram. You know that the diya is increased if you kill one of your relatives. The diya is increased when you kill one of your relatives. Is this because of this qaida? No, it is not. Because if you kill anyone other than your son, you're subject to qisas. Keep in mind that Imam Malik said that if you kill your son and we're sure that you intentionally killed your son, you're still subject to qisas. But the majority said you're never subject to qisas if you kill your son. And why is this? Not because kids are disposable, but because it is so unlikely that a parent will kill their child unless this was unintentional, or even if it is intentional, it is because they were not in the right state of mind. Like this, it's just like not, okay? But Imam Malik said, if we are sure, like أَجَّعْتَهُ وَذَبَحْتَهُ, if you make him lie down and you slaughter him, and we're sure that you did it intentionally, then you're subject to qisas. But otherwise, the three other imams said you're not subject to qisas. But if you do this to your uncle or to your nephew, are you subject to qisas? Yes, you are subject to qisas. Why are we increasing the diya in this case if the family decided to take the diya versus the qisas? Because of the sanctity of the relative. Like you violated, like you did something that is shocking to the society. You know, you killed your nephew. You know, how dare you? So we will, even if they don't ask for qisas, we will increase the diya. And that brings us to the end of this. Sorry, but we had to finish these 4 قواعد. قولوا قولي هذا واستغفر الله لي ولكم سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك. So let's come back at 9:30, inshallah.